The Senate Committee on Government Affairs will go into subcommittee consisting of the members Senator Krasner, Senator Daley, and Senator Flores. In subcommittee, we'll be reviewing Senate Bill 279. We do have Senator Pezzina here and Mr. McCann joining us. Good afternoon, whenever you are ready.
Good afternoon, Chair Flores and committee members on the Senate Committee of Government Affairs. For the record, my name is Julie Pezzina, and I represent Senate District 12 in Clark County, and I'm before you today to present Senate Bill 279, which revises provisions relating to law enforcement. This bill aims to enhance transparency and fairness in the investigative process for peace officers. And with me today to present Senate Bill 279, and I should also say there is a second amendment which should be on your desks. Hot from the presses. With me today is Rick McCann and Andrew Regenbaum with the National Association of Public Safety Officers and the Nevada Law Enforcement Coalition. At the chair's pleasure, I will provide some brief overview remarks before handing it over to my co-presenters. Currently, law enforcement agencies are authorized to conduct investigations into peace officers based on complaints or allegations of misconduct. These investigations often involve interrogations and hearings, which require written notice to be provided to the peace officer involved. The notice must include a summary of the alleged misconduct and other relevant details. However, there is a need to further specify the details included in such notices and to clarify the rights of peace officers during these investigations. As such, Senate Bill 279 requires that written notices provided to peace officers must include specific details about the alleged misconduct, including all relevant facts and the rules or policies that have been violated. Additionally, the bill mandates that peace officers who are compelled to appear as witnesses must receive at least 48 hours written notice, as are the officers that are subject to the investigation. At this point, I'd like to hand it off to Mr. Rick McCann and remind everyone to look at that second amendment. Thank you.
Good afternoon, welcome.
Thank you. Good afternoon, Mr. Chairman, members of the committee and staff. I always remember the staff. I just want you to understand that. For the record, my name is Rick McCann, and I am here today representing the Nevada Association of Public Safety Officers and the Nevada Law Enforcement Coalition to help present SB 279. Nevada Revised Statutes, Chapter 289, is otherwise known here in Nevada as the Nevada Peace Officer Bill of Rights. Quite simply, law enforcement officers are afforded basic due process rights, such as the right to be notified in a timely manner when they are to be interviewed by Internal Affairs, and the right to be notified with some specificity as to what the heck the misconduct is that the officers are facing. This is just common sense and it's simple fairness to the officers. But occasionally there's an agency that plays a little fast and loose with some of these rights, and that then brings us here today because we need to tighten things up a little bit. With that, and this is the shortest presentation you've ever heard me give, so I think you're probably happy. With that, I'll turn it over to Mr. Andrew Regenbaum to review the bill with you and let you know of some of the specific reasons why we're here today. Thank you.
Good afternoon, welcome.
Thank you. Good afternoon, Mr. Chairman, members of the committee, and staff, as Rick pointed out. I'd also like to thank Senator Pezzina for sponsoring this bill and for Mr. McCann for all the hard work he's done in helping me prepare the bill for you. As you heard, my name is Andrew Regenbaum, and I am the Executive Director of the Nevada Association of Public Safety Officers. We represent approximately 25 different law enforcement associations and their members around the great state of Nevada. As you know, NRS 289 is the hallmark law that provides due process rights to law enforcement officers. It is an excellent law, but in recent years, we have seen an increasing number of agencies finding ways to circumvent the intended language of the law in order to manipulate the outcome of investigations. The purpose of the bill before you, Senate Bill 279, is to codify the due process protections originally intended for 289 into specific words. So what do I mean by that? First, originally the drafters of 289 intended for the subject witness officers for subject officers and for witness officers to be given 48 hours notice of any investigative interview. Unfortunately, while that language is very specific as to the subject officer, some agencies have tried to suggest that a witness officer is not entitled to that same protection of that 48 hours of notice. Our language simply clarifies that the 48-hour notice applies to both a subject officer and a witness officer. The more significant additions proposed by this bill pertain to NRS 289.060 subsection 2, which is the notice provision that is required to be provided to an officer prior to an investigation. 289.060 subsection 2B requires that an agency provide the officer with, and I quote, a summary of the alleged misconduct, close quote. This seems simply enough and should be followed without question by any law enforcement agency. The intent of that statement is to avoid fishing expeditions or witch hunts against any law enforcement officer. In fact, it's simple due process that would be provided to any ordinary citizen. But while some of the agencies in our state follow the clear intent of the language and give an actual summary, we have found more and more that unfortunately there are agencies that are not providing actual summaries and leaving officers open to questions without limitations and for which he or she were not able to properly prepare to answer. For example, we have seen one city provide an officer with an interview notice about an alleged nepotism policy violation with a coworker. Yet that interview, questions came up about misuse of computers, harassment of an unrelated officer or coworker in another situation. None of this was contained in the notice, despite internal affairs knowing the nature of the allegations that they intended to ask questions about. Another example, an officer was noticed for an interview about an alleged rude and discourteous traffic stop that, let's say, happened on the 1st of January of this year. The notice indicated that he would be questioned about a rude and discourteous stop on January 1st to the present. That officer was then questioned about 5 additional stops that occurred in February, March, and April of that year. And the officer was disciplined with regards to the unnoticed March stop, which he never knew he would be questioned about, and was unable to answer certain questions because he had no recollection of the event whatsoever. Frankly, this entire event, either of those examples, were unfair. Both cases were an ambush and resulted in discipline that is now being challenged with unnecessary arbitration that goes on between the associations and the cities or agencies that they work for. This would not happen to an ordinary citizen and should not be allowed to happen to a law enforcement officer. In order to fix these issues, with the help of Senator Pezzina, we have proposed common sense legislation and language that will simplify and clarify 289.060 subsection 2B. The language in the amended or second amended bill that's before you requires the agency to include in the summary the date, time, and location of the alleged misconduct, as well as a summary that includes a specific description of the misconduct or performance problem. This is not a difficult requirement, creates no real burden for the agencies involved. In fact, if any additional new information is discovered during the interview, NRS 289 already has provisions to stop the interview, give the officer another new notice with additional allegations, and then restart the interview. Therefore, there is no prejudice whatsoever to the agencies, despite anything they may say to the contrary. Now, I will tell you, for all the committee members, that a few agencies already follow these protections that we propose in Senate Bill 279. Metro, for example, gives date, time, and place in their notice, and it's a part of their collective bargaining agreement. Lyon County lists potential policy violations for their officers in their notices. But unfortunately, many other agencies do not follow the law and need to be guided more specifically by this language which we propose placing in the law for it. Senate Bill 279 will do this and will protect our officers' rights. Ladies and gentlemen of the committee, it is for this reason that I ask that you please support Senate Bill 279 so that we can do our part to protect the men and women who tirelessly protect us each and every day, 24 hours, 7 days a week. Thank you.
Thank you all three for the presentation. Members, any questions? Seeing none, I have just one quick one. When you addressed the concern of saying you're not following 289 to the intent with these particular cities or jurisdictions that you were working with, what was the response?
So we placed the objection.
Your name for the record.
Oh, I'm sorry. My name is Andrew Regenbaum, and in response, sir, the objection is placed on the record, but we have no ability to stop an improper question because then the officer would be held to be insubordinate. So the objection is placed on the record. Internal Affairs continues with their questioning, thanks me for my input, and then we end up with an arbitration where ultimately, based upon the provisions of 289-085, the improper question should be thrown out and the entire process removed. But that requires that time wasted with the process of arbitration, money wasted with the process of arbitration, and frankly, a lot of anxiety to the officer.
And then the other question regarding the witnesses who were being asked to come in and testify or address a particular matter. Typically, were they being asked to show up the very next day or in a few hours? What was happening in those scenarios?
So, again, Andrew Regenbaum. And in those instances where that's happened, we were told that 289 does not protect the witness officer in terms of timeliness of notice, and that the witness, in one instance, was actually asked to come off the road and immediately appear before Internal Affairs, regardless of whether that individual's representative was available, which is also a protection afforded under 289. So in that instance, we believe multiple parts of the law were violated, and so that's how that's happened.
Fair enough. Thank you again.
Thank you.
Members, no questions. Seeing none, I'd like to invite all three of you to sit back in the gallery. And at this time, I'd like to invite those wishing to testify in support of Senate Bill 279 to please come forward. Good afternoon. Welcome. Good afternoon. Welcome. Whoever wishes to go first.
Good afternoon. My name is Sean Tebow, and I am the president of the Henderson Police Officers Association, where I represent over 400 officers of the Henderson Police Department. I came to speak in favor of this bill today. During my tenure, I have witnessed the abuse of the IA notice process, where officers have not been given sufficient notice of an IA investigation, and by being too vague in the description of the alleged violation. NRS 289-060, as you know, states that and I quote, "The notice provided to the peace officer who is the subject of the investigation must include A, a description of the nature of the investigation, B, a summary of the alleged misconduct of the peace officer, C, the date, time, and place of interrogation of the hearing, D, the name of the rank of the officer in charge of the investigation and the officers who will conduct any interrogation or hearing, and E, the name of any other person who will be present at the interrogation or hearing, and a statement setting forth of the provisions of subsection 1. If the proposed changes to 289-060 are enacted, we will ensure that the NRS is followed and there would be no violation of Section 3C, which states, as you know, I quote, "The law enforcement agency shall limit the scope of the questions during the interrogation or hearing to the alleged misconduct of the peace officer who is the subject of the investigation." This would eliminate the fishing/witch hunts that Director Regenbaum was referring to. Unfortunately, this has not been the case as currently. I am also keenly aware that witness officers have not been given 40-hour notices as well. I have personally had to barge in on and stop an IA investigation due to the department not providing the proper 48-hour notice, and thus violating the officer's rights in accordance with the NRS. Your consideration of the passage of this bill is greatly appreciated and will serve to protect your peace officers' rights in the future. Thank you.
Thank you for joining us. Good afternoon, welcome.
Good afternoon, Chair Flores, committee members. My name is Jason Lesher with the Washoe County Sheriff Deputies Association. We appreciate this bill being brought forward and believe it is a positive step toward ensuring thorough and fair investigations. We expect and demand that our police officers are honest and transparent in their duties, yet they are often required to answer questions regarding misconduct with only a general or vague idea of what the subject matter will be. The notices that order them to appear routinely lack specific names, dates, times, or reference to cases. This bill gives officers the ability to better understand the nature of an investigation, which will allow them to more accurately answer questions during an interview. We believe this will result in higher quality internal affairs investigations and will increase the public's confidence in our law enforcement officers. Thank you.
And thank you for joining us. Good afternoon.
Good afternoon, Chair Flores, members of the committee. My name is John Abel, Johnabel. I represent the LVPPA in Las Vegas. This language already exists in our CBA. Also, as a rep myself who has repped many officers in internal affairs, and I've seen notices with vague writing, we have been able to contact the internal affairs investigator and have them change the language in the notice to comport with our CBA and NRS 289. So for that reason, we support the bill. Thank you.
And thank you for joining us. Good afternoon, welcome.
Good afternoon. My name is Harrison Porter. I represent LVPMSA, the Metro Supervisors. We are in favor of this bill, just to echo what John Abel said. It is on our CBA, and we think this would be a good addition. Thank you.
Thank you for joining us. Good afternoon.
Good afternoon, Chair Flores and members of the committee. My name is Josh Martinez with Las Vegas Metropolitan Police Department. I'm going to turn it over to our Labor Council that assisted the amendment here and offer our support.
Good afternoon, Chair. So we did work with the other side to come to some agreements, and with the amendment that was put in front of you guys today, that is the language that currently mirrors our CBA language, and we're currently practicing, so we are in support of this bill as well.
Thank you. And can you just state your name for the record?
Yes, Jamie Frost.
Thank you.
Jamiefrost.
Thank you again for joining us. Good afternoon, welcome.
Sorry. Chairman and members, my name's Jim Dunlap. I'm a member of the Henderson Police Supervisors Association and also a 30-year law enforcement officer. And through my tenure, I've seen many officers go through this process and have seen recently the process being abused by other jurisdictions. I'm also a member of Nevada Association of Public Safety Officers that help represent the 25-plus organizations around the state. And yes, some organizations do follow the rules as the gold standard, as we would call it, that Metro already recognizes in their CBA. And all we're asking is the other jurisdictions still be afforded those same rights that other jurisdictions receive. Every police officer in the state should have the same rights and rights afforded to them, no matter how big or small that jurisdiction is. So again, I would ask the committee and the chair to pass this. Thank you.
And thank you for joining us. Is there anybody else wishing to testify in support? Seeing none in Carson City or Las Vegas. BPS, do we have anybody wishing to join us over the phone in support?
If you would like to testify in support of SB 279, please press *9 now to take your place in the queue. Sure, you have no callers wishing to testify at this time.
Thank you. At this time, I'd like to invite those wishing to testify in opposition to Senate Bill 279. If you could please come forward, Carson City and Las Vegas. Good afternoon, welcome.
Good afternoon, Chair, members of the committee. Warren Hardy representing the Nevada Urban Consortium. I'm an unhappy victim of the committee rules today. I understand that the amendment that was agreed to today addresses all the concerns we have. However, we just barely got a copy of the amendment. I've sent it to my members, and so pending them seeing that, we have to remain in opposition. But I'm highly optimistic that the amendment that was adopted today or presented by the committee is going to address our concerns. Thank you.
Understood. Thank you for joining us. Very soft opposition. Is there anybody else wishing to come forward in opposition to Senate Bill 279? Seeing none, BPS, do we have anybody wishing to join us over the phone?
If you would like to testify in opposition of SB 279, please press *9 now to take your place in the queue. Caller with the last three digits of 345, please press *6 to unmute yourself. Please continue.
Yes, I was trying to testify in favor of Senate Bill 279. I don't think I hit my keypad quickly enough.
No worries. We are in opposition, but please continue. We'll move to support. Please state your name for the record.
Yes, good afternoon, Mr. Chairman and members of the committee. For the record, my name is Detective Andrew Kellum, spelled Kellum. I'm the president of the Elko Police Officer Detective Association. In Upper Nevada, our association has seen a concerning history of internal affairs investigations being conducted with little to no summary of alleged misconduct described in the internal affairs notices. Passage of this bill will improve the internal affairs process by clearly and transparently describing the specific grounds for the investigation. On behalf of the Elko Police Officers Protective Association, I support the passage of Senate Bill 279 and its significance for peace officers. Thank you.
And thank you for joining us. And just for the sake of clarity, that was in support. BPS will go back to opposition to Senate Bill 279. Do we have anybody wishing to join us in opposition over the phone?
Chair, you have no more callers wishing to testify at this time.
Thank you. Is there anybody wishing to testify in the neutral position, Carson City or Las Vegas? Seeing none, BPS, do we have anybody wishing to join us in the neutral position over the phone?
Chair, your public line is open and working, but you have no other callers at this time.
Thank you. Senator Pazina, any closing remarks you may have?
Thank you so much again for hearing Senate Bill 279. I would like to share that a number of members of the AFL-CIO and labor community had planned to come to testify in support. Due to the change in timing, unfortunately, we weren't able to communicate that to them, but I'm sure they can always reach out later if there's any questions. And then I just say in conclusion that SB 279 attempts to enhance the fairness and transparency of law enforcement investigations involving police officers, and thank you all so much for your time.
Thank you. And at this point, it's the world versus Hardy. So, I don't know. Thank you. And with that, we'll go ahead and close out the hearing on Senate Bill 279. For anybody who is following along and just recently joined us, I wanted to clarify why we are presently in subcommittee. We do not have a quorum, so we're in subcommittee so that we can move forward with the hearings. Today at 4:30, we're scheduled to do the state of the judiciary. And my concern is that if we started at 3:30, we would have to stop in the middle of a bill presentation, go to the state of the judiciary, and then make our staff come back 6, 7 p.m. In an effort to avoid that, we were hoping to meet as soon as possible. So just for those of you who just logged in and you're trying to figure out what's going on, we are in subcommittee. We're not going to be taking any action at this time. However, we may take action once we have an actual Senate quorum and, a Senate Government Affairs Committee quorum. Thank you again, Senator. It's great seeing you. All right. Okay, I got you. And at this time, our very own Senator Skip Daly will be presenting Senate Bill 340. Fair enough. Whenever you're ready, Senator.
Thank you, Mr. Chair, members of the committee, depleted as it may be, and staff, I guess. Happy to be here to present Senate Bill 340. So this area on the Legislative Commission and the constitutional provision that would allow the Legislative Commission to potentially do more than just review regulations is, I've found not to be very well known by a lot of people, so I'll do my best to try to walk you through and explain the best we can. And then what the reason is for this particular bill. So if you read the digest on page 4, line 143, it states that the Nevada Supreme Court has held, quote, courts should not substitute their own construction of statutory provisions for a reasonable interpretation made by an agency. So that interpretation that we have in the state of Nevada, that was how they used to do it at the federal level as well. The Supreme Court had a decision, was known as the Chevron decision, where they gave deference to the regulatory agencies on that. So recently, the United States Supreme Court overturned Chevron and shifted most of the interpretation to the courts. Now, if an agency under its regulatory authority tries to enforce now, if they do that with the Chevron being overturned, the adopted rules or policy can be challenged by allowing the court to determine whether the agency was expressly granted such authority by Congress. You know, we can't get anything through Congress, so essentially all of the issues over rulemaking and regulations is now shifted to the court at the federal level. By overturning Chevron at the federal level, the courts have created a great deal of uncertainty. So I believe it's only a matter of time before a case makes its way to Nevada, where the litigants will cite the federal case overturning Chevron and argue that our Supreme Court should overturn its previous decision regarding giving deference to regulatory agencies. In Nevada, an executive branch agency can only adopt or promulgate a regulation if it has been authorized to do so by the legislature. Also in Nevada, by and through a constitutional amendment, a legislative body known as the Legislative Commission has been authorized by law to review and approve any proposed regulations before it can take effect. Now, the Legislative Commission can review, but they can accept or reject. They can't do any amendments or anything at that time, and this bill doesn't propose to change that. At the federal level, the argument has been, since the overturning of Chevron, that agencies have to be more specifically authorized by Congress on what the agency can or cannot do. Basically, under the current state, when an agency gets challenged, the court has essentially taken control over the regulatory process that properly belong to the legislative and the executive branches of the government. Because Nevada's Constitution allows the Legislative Commission to not only review, but to suspend or nullify a regulation if authorized by law, SB 340, if passed, will allow the Legislative Commission to interpret the regulatory authority granted by the legislature and to interpret the legislative intent behind the regulation. This authority can only be used if SB 340 is passed by the Legislative Commission if a dispute that might otherwise go to the court arises, keeping the determination over the authority and intent between the legislative, the authorizing branch of government, and the executive, the enforcing branch of government. I know some of you might be thinking that this might be taking away from the executive, but I don't think that's the case. I do think that in this case, I believe that under the structure of this proposal and as allowed by the Constitution, it keeps the regulatory process in Nevada between the executive and legislative branches where it, I think, more appropriately belongs. Legislature allows, the executive branch then promulgates, and then has the enforcement responsibility. The executive branch is charged with faithfully executing and carrying out the laws that are enacted by the legislature. I think this process will be better for both the executive and legislative branches. In the majority of the cases, the executive and legislative branches are in agreement over the regulatory functions of government, and I believe it will be better for both the executive and legislative branches if the courts had a more limited role. As I mentioned earlier, much of the dispute over the regulatory interpretation is being held up by the court and pushed back onto Congress at the federal level. I think it is better to use the process available to us under our Constitution to eliminate as much uncertainty in our state, and who better to review and determine legislative intent than the legislature. With that, I will walk through the bill. Section 1 spells out the constitutional authority of the proposal under the separation of powers in Article 3. Section 3 establishes the process for a person to petition the Legislative Commission to review the regulation regarding the agency's authority and legislative intent. I would like to point out that our legislative commission can only use the provisions of this bill if there is a dispute submitted to it for review. We can't go fishing, we can't pick one up, we can't say, hey, I don't like how someone's doing that. There has to be a dispute in order for it to get to us. In section 3, subsection 3, in that section, I would propose a small amendment. So I'd propose to amend that section that if a dispute comes, instead of just going to the chairman of the legislative commission, that it would be submit the petition to the subcommittee to review regulations for a recommendation back to the full commission on how to proceed. I don't have anything written up, just conceptual, and we'll work on that as we go forward. You can see the rest of the review process outlined in section 3. I would also mention here that in subsection 12, and you will see it throughout the bill, that the determination made by the Legislative Commission is not subject to judicial review. Section 4 requires the Legislative Commission to adopt regulations for the administration and consideration of any adjudication process. Section 5 is conforming language regarding judicial review. Section 6 deletes a definition of what a regulation is not, and as I recall, this was suggested language by the LCB from AB 403 back in 2017, where we had a similar bill, but this one's a little more narrow. Section 7 is also suggested LCB language to ratify regulation adopted as of February 2025. It was in the previous bill before with the old dates, and I believe that's LCB recommendation. Section 8 is cleanup language regarding how long an agency has to submit regulations for review. Currently, they have to get it in front of the Legislative Commission within 2 years, or it has to be at least adopted within 2 years. I think this cleans up and says they got to get it in front of the Legislative Commission in that 2-year period. Section 10 and 14 is conforming language and requires that a copy of the written endorsement by the governor for emergency regulations must be submitted with proposed emergency regulations. So as it is now, if you're going to adopt an emergency regulation, the agency has to go to the governor and say, hey, we're going to do this. The governor has to endorse that or sign off on it. This just clarifies that when they then submit it to the Secretary of State to be put in, that they have to include that signed declaration from the governor that he's approving the emergency regulations. Section 11 is also conforming language. Section 12 is LCB cleanup language allowing for the electronic publishing and adoption of regulations. They requested that last time, but the bill got vetoed, so we're trying it again. Section 13 and 14 is also cleanup language regarding information that must be submitted to the LCB after an agency has adopted a regulation and before review by the Legislative Commission. Conforming language in Section 15. And then Section 16 is in regard to requests for declaratory judgment, requiring the courts to give great deference to any determination made by the Legislative Commission, as I outlined earlier, trying to keep it as close to the legislative body and the executive branch for the two agencies that have granted the authority and then have the enforcement authority. With that, happy to answer any questions. I don't have the bill right in front of me, so take it easy on it.
Thank you, Senator Daly. Members, any questions? And Senator Rogich, I know that you just came in. I know you were presenting in Senate Education. We are in subcommittee, and just in the interest of time, we're hoping to be able to try to finish before our 4:30 State of the Judiciary. Senator Daly, I think I can maybe jump in and just go through a few of the questions that I think we've heard, maybe from some of the opposition and or just in general. The first one is if they make a request to the chair of Legislative Commission, and then you go through kind of the steps in Section 3, wherein you'll make a determination, and you make a determination that it doesn't meet one of the 3 criteria, what happens to, and I understand that you're going to submit something in writing explaining why you're not going to make a determination for whatever reason because it doesn't fall within one of the 3 criteria. What happens at that point? Does it go to the court?
Skip Daly again for the record. Thank you for the question. similar to when you put in a complaint to the court on the various things. They look at it. If they find that it's lacking, they dismiss it. I'm assuming this would be similar to that. On the provisions in there where the Legislative Commission will adopt regulations, that's where I think some of that procedure, the due process portions will be worked out. If they do go to a hearing, you know, what's the notice requirement, those types of things. That'll all get outlined in the regulation, similar to other hearing type procedures on what it is that you would have to do. And then if I recall correctly, what can be brought up when they do actually bring an agency in if they have questions and they have a hearing. Doesn't necessarily have to be limited to those things that are on the notice. If other things come up, the Legislative Commission is able to do that. But the intent behind that and getting a dispute done at this level, like I said, is to, most of the questions are over, do they have the authority under the statute? A lot of that is reviewed by LCB when they turn in the regulation. A lot of that is reviewed by the Legislative Commission when they're reading the potential regulation and either approving it or rejecting it. The authority is listed out in there. So that's the type of deference that we're trying to look at that the courts would have. In theory, someone could go to the court and say, we want a declaratory judgment, but the language in 16 says if the Legislative Commission is, they got to give deference to the fact that it went through the hearing process, it was approved by the legislative body, and was found to have met the regulatory authority and the intent. They would have to give deference to that.
And this is always true when it's going to be true with a judge that may be impartial. It may be true in a whole host of scenarios where you might not like the chair, and you think that the chair is going after against a certain agency or being biased. How do you see that playing out? The concerns of bias that some folk may have raised. Because ultimately, it's the chair that makes the call versus LCB, correct? And I think the only thing that I think some of the stuff that we had to come in was just talking about in the scenario where we think we have a bias to X, Y, Z. What do we do in that scenario? And again, I'm just playing devil's advocate.
Understood. Skip Daly again for the record. So the Legislative Commission can't on its own volition go out and say, hey, agency, I think you're doing it wrong, and somebody's got a vendetta or whatever. It would have to be a dispute or complaint or somebody that's alleging that, they're outside their authority or they're, we got a new administrator of whatever agency it is, and this is how the regulation was administered and interpreted for, a long period of time, and now we have a new sheriff, so to speak. You have a new administrator, and they change that, and they say, well, I think the interpretation and the words allow me to do it much differently than I have before. Then there would be that dispute that you would be able to bring to the Legislative Commission to try to get that adjusted. And the Legislative Commission, again, we couldn't promulgate the regulations, but we could suspend, we could vacate the whole regulation, we could suspend some or all, if you read the language in there. So I think we have much greater flexibility on some of that type stuff. So it's not where anyone's going to have the vendetta, and it's not just the chair either. That's why I proposed the one conceptual to say, send it to this subcommittee to review. I think you have to have at least 3 people on that from the Legislative Commission. So it has a little broader view of the direction that we would go. And it was just a verbal deal I made in the presentation about making that change.
Thank you for that clarification. The only other question is, how often do you think we'll be engaging in these types of conversations? How often do you see it now, do you think? Per year or session, whatever way you want to kind of see those numbers.
Skip Daly again for the record. Well, obviously, we don't have the authority by law right now to suspend or nullify, so I don't believe it's ever happened. We only have the ability to review. So the process now is the legislature would authorize a executive branch agency to promulgate regulations. They then, completely in their court, whether they do it or not, unless we said you shall do it and give them direction, Then they would bring the regulation in whatever manner they believe is in accordance with the direction, or to administer their statutes, and which is the way most of them are written, is they can adopt regulations to help them administer the statutes of which they have jurisdiction. Then they would propose regulations, they would send out notice to interested parties, advertise through the regular process. They would have a workshop, bring in interested parties. People could come in and say, this is what we like, this is what we don't like, this is what we suggest, give their comments. But the executive agency promulgating the regulations has complete control over that process. They don't have to take any of these suggestions if they don't want to. Often they do. That's why the stakeholders go. Then after that, before they adopt it, they have to have a hearing. So then they would have a hearing, and then the agency would adopt the regulation. From that point, they would turn in their adopted regulation to the Legislative Council Bureau, and they do their magic and write it into a format that's going to end up in a regulation. So sometimes it changes a little bit. Then it would be submitted for review by the Legislative Commission. The Legislative Commission would read it, and they would either adopt the regulation and it would go into effect, send it to the Secretary of State, and would be added to the docket, hopefully electronically if this passes. And if the Legislative Commission does not adopt it, then it's rejected and they can start over. They can say, okay, we're done. They usually get direction, having served on the Legislative Commission several times, from the commission on what the issues were, and they have a good idea of what needs to be corrected or changed in order to satisfy the issues that came up. So that's the process. We don't have the ability to nullify or reject or amend, and we're not asking to amend. But if somebody did a presentation at the Legislative Commission and said, this is what we think it means, this is how we intend to operate, when you ask them questions and they answer them, if then sometime in the future they're not administering that in the same fashion and there's a complaint, then we would be able to come back and say, you're outside of the intent of what you originally said you were going to do, and in that case, the Legislative Commission could take action.
And we have had a few folk join us since the start of the presentation. Members, any additional questions on Senate Bill 340? I don't see any, and I think we'll have some folk that may come in and can clarify some other stuff too, and we'll take it from there.
It's an esoteric area that maybe they'll think of questions later, but if you don't know and you haven't read all of it, it's hard to follow.
Chevron deference, I know, is every law student's favorite landmark case, I'm sure. So thank you, appreciate it. We're going to invite those wishing to testify in support of Senate Bill 340 to please come forward. I do see somebody in Las Vegas. Good afternoon, welcome.
Good afternoon, Chair Flores, members of the committee. Thank you for the presentation, Senator Daly. My name is Anahit Baghshatsyan. For the record, that is ANAHIT BAGHSHETSYN, and I'm a research assistant at Nevada Policy. Nevada Policy strongly supports SB 340 that aims to strengthen the legislative oversight over agency regulations. We see this bill as a way to establish a dialogue between the public and the Legislative Commission. As Senator Daly went over the Section 3 and the regulations that will be allowed to be disputed, I'm not going to dive deep into it, but I'd like to accentuate that we see this as a mean for the public to address burdensome and unclear regulations and also strengthen the government accountability in the process. Additionally, Legislative Commission is a great body to bring these disputes forward to because it's comprised of 6 assembly members and 6 senators, which would in turn reflect also bipartisan and how would you say that? Bipartisan and I guess representative support of various disputes. Finally, the bill will enhance transparency and public participation also by requiring both oral hearings and electronic publishing of all the disputes and all the hearings. So just to conclude, SB 340 is seen as an amazing tool to encourage public dialogue, and we would love to see the committee support it. Thank you very much for your time today.
And thank you for joining us. We also did receive your letter that was submitted, so thank you for doing that.
Thank you.
At this time, anybody else wishing to come forward in support? Seeing none, BPS, do we have anybody wishing to join us in support over the phone?
Chair, your public line is open and working, but you have no callers at this time.
Thank you. At this time, I'd like to invite those wishing to testify in opposition to Senate Bill 340. If you could please come forward either in Carson City or Las Vegas. Seeing none, we'll invite anybody wishing to join us over the phone. BPS, please.
Chair, your public line is open and working. You have no callers at this time.
Thank you. And lastly, we'll invite those wishing to testify in the neutral position for Senate Bill 340, Carson City or Las Vegas, to please come forward. Seeing none, BPS, do we have anybody wishing to join us over the phone?
Chair, you have no callers at this time.
Thank you. Senator Daly, any closing remarks, please?
Thank you, Mr. Chair, members of the committee. Again, Skip Daly for the record. And I know there are some people that maybe missed the meeting, time change, and those types of things that have some concerns. I think most of it, of what I heard, was over the judicial review and that and the involvement in the courts. I have a couple of ideas, and I'm going to work with that. I'm going to talk with legal and try to see if we can't figure out a way to make that more acceptable on that level. Other than that, I do not have any other comments, but I do want to work on that and appreciate you guys' time.
Thank you, Senator. At this time, we'll go ahead and close out the hearing on Senate Bill 340. Madam Secretary, I would like to open up formally the Committee on Government Affairs. The Senate Committee on Government Affairs will come to order. Madam Secretary, if you could please call the roll.
Senator Daly? Here. Senator Ellison? Senator Krasner? Here. Senator Neal? Senator Orenshaw?
Here.
Yes?
Present. Please let the record reflect we do have 5 members present. We do have a quorum. Please mark Senator Neal as absent excused, Senator Ellison as absent excused. And we will continue with the work we were doing in subcommittee now in Senate Government Affairs Committee. We'll hear Senate Bill. Oh, before we do that, Senator Daly, if I could have you have a seat. Members, you should have received notice on a possible work session document for Senate Bill 282. I want to give you all an opportunity to have that document in front of you. I know that we preemptively notified you of it, but I wanted to make sure that you do have it in front of you. Seeing, I think everybody has it in front of them. At this time, I'm going to hand it over to our committee policy analyst to go over the work session document. Please.
Chair, for the record, Jan Stinsbeck with the Research Division of the LCB. I believe the only bill in work session today is Senate Bill 282, which was heard in this committee on March 12th and requires the Department of Health and Human Services to establish and administer a grocery initiative to award grants of money and provide technical assistance and other information to certain grocery stores in the state to expand access to healthy foods and food deserts in areas at risk of becoming food deserts. The bill further requires the Council on Food Security to research and develop recommendations related to food insecurity in urban and rural food deserts in the state and to submit a written report to the 84th session of the legislature summarizing its research and recommendations. Lastly, the bill appropriates $10 million to the Department of for the Grocery Initiative to award grants of money and provide technical assistance and other information to grocery stores in the state. There was one amendment proposed to the bill, which was presented during the bill hearing. The amendment was proposed by Alison Herzig, Chair of the Governor's Council on Food Security, which proposed to remove the Council on Food Security as an entity that designates an area as a food desert and instead authorizes the department by regulation to designate one or more existing areas as a food desert for food insecure area. The proposed language is attached to the work session document. Thank you, Chair.
Thank you. At this time, I'd like to entertain a motion to amend and do pass Senate Bill 282.
So moved.
Senator Daly has made Senator Orenshaw has made the motion to amend and do pass Senate Bill 282. Do I have a second? Senator Daly has seconded that. Members, any discussion? Senator Krasner, please.
Thank you, Chair. I really like the concept of this, but I'm a little concerned about the $10 million appropriation. So I think I'm going to have to vote no and reserve my right to change my vote prior to floor. Thank you.
Thank you. Senator Rogich, please.
Thank you, Chair. I'm going to vote yes, but reserve my right to change my vote on the floor.
Thank you, Senator. Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
Those against say nay. Please let the record reflect, we have 4 ayes from Senator Rogich, Daly, Orenshaw, and Flores, and 1 nay by Senator Krasner. Motion carries. And we will ask that our majority leader please do the floor statement on Senate Bill 288. Next on the agenda, we will go back to our bill hearing for Senate Bill 313. Senator Daly, whenever you're ready.
Thank you, Mr. Chair, members of the committee. Skip Daly for the record, here representing Senate District 13. So, excuse me, the genesis for Senate Bill 313 came to me from serving on the audit subcommittee of the Legislative Commission. One of the audits that was presented there brought into focus a little bit on what was called the questionable use of sole source waiver procedures, sole source waivers. The audit report showed that a contract went from its original scope and amount, and I don't remember the exact dollars, but it was somewhere around $90,000. And then over the course of several extensions, without competitive bidding, went to in the neighborhood of 16 million, without ever going back for competitive bidding. So when I first submitted the bill for drafting, I had some ideas on the direction that I wanted to head, but not that information regarding some of the circumstances that resulted in the audit report we received. So I was able to reach out and meet with the Purchasing Division Administrator, Gideon Davis, who's here today to answer questions on a technical issue. He's not here to support or anything like that, but he will be able to answer questions. So I've been working with Mr. Davis on the amendment you should have before you, and that's the one I'm hoping to work off of today. So my goal with this bill was to tighten up the use of non-competitive contracts and to strengthen the policies on competitively bid contracts, but allow for the appropriate amount of flexibility for different types and lengths of contract for services, goods, etc. And I'm repeating some of the information that was given to me by Mr. Davis, so that's why he's here in case you have specific questions. So in other words, a one-size-fits-all approach will not be in the best interest of the state. Accordingly, with the help of the purchasing administrator, I'm proposing the following amendments to SB 313. So Section 1, Subsection 1 requires a using agency, and that's the term that purchasing uses, I guess, to submit a report to justify entering into a contract without competition. Section 1, Subsection 1C, where we are adding a requirement for the department to post a notice if a non-competitive contract is awarded, and subsections 2, 3, and 4 provide for the two-step process that starts with an informal objection process, resulting in a letter of determination to either withdraw the non-competitive award or proceed with award, and provide any justification for that award. The second step in the appeal would be a formal appeal procedure, which is an existing law in 333.370. Section 1, Subsection 5 requires the administrator to annually provide the reports generated by subsection 1 to the interim finance committee. I added that we should send it to the legislative, audit division and the audit subcommittee of the legislative commission in even-numbered years in the interims. Section 2, subsection 1 adds services to this section of purchasing and provides purchasing provisions and specifies that the period of service must not be longer than 10 years. We went through back and forth, and I'm sure the administrator can give you more examples on why that is fair, because I will say I struggled with that language, but after several discussions and with the addition of the language to adopt regulations under subsection 6, I think this bill will get to the tightening up we need without completely eliminating the flexibility that is sometimes warranted. Section 2, subsection 3 puts some process around requests for contract extensions beyond the originally intended period of performance and requires the administrator to direct the using agency to solicit and advertise for a new contract. The nuance in there is that when you put out the original intent, it may or may not include extension provisions. So sometimes it does, and if they go past that extension, which was allowed in the original contract, they have to go and say, hey, we want an additional extension. This would allow for that. That extension can't be more than 4 years under the provisions here, and it has to come with, if it's granted by the administrator, direction to that agency that you got 4 years. If we give the extension, might be less, but you have to put this out to competitive bid. And then in our discussions, there were several examples where the agencies still aren't doing it, a variety of reasons. Maybe they don't have staff, maybe they're just ignoring whatever. And that's where we got into some of the other provisions here, which I'll get to. So I asked Mr. Davis, if asked, Mr. Davis can explain the types of circumstances that have led to the repeated extensions. Section 2, subsection 5 will require a using agency that fails to solicit and advertise for a new contract to appear before the Legislative Commission to explain why the new competitively bid contracts have not been awarded. Again, in the discussions, a lot of this is starting with the budget process we currently have. I'm not trying to say that it's wrong or right or anything, but some of it has resulted in this over time. And I think the only way it's going to get corrected going forward is for legislators to learn some of the issues. So I wanted to send it in front of the Legislative Commission for that review so they can hear the explanation, they can hear how they got there, and then hopefully start to learn, as I did from the Audit Committee, what do we need to change to make sure that we're acting in the best interest of the state, that we're competitively bidding, public dollars are being used appropriately, and that we're getting the best bang for the buck, which is why we even have a purchasing division and all the competitive bidding in the first place. As I mentioned previously, Section 2, subsection 6 requires the administrator to adopt regulations to address the policy for the term, solicitation and award of contracts, policy for extensions of contracts, and policy to ensure contract extensions and sole source contract are not used to avoid competitive bidding procedures. I thought about trying to put some of that into the statute, and I believe that that's better left to the regulation. There are some procedures and various things in my discussions with the administrator that are in the SAM, the State Administrative Manual, which can be changed fairly easily. That should be elevated up. Some of it's elevated up to a statute in this proposal. It should be elevated up to a regulatory process that's a little more formalized. So I think with that, and I hope you were able to follow that pretty well, we've struck a balance between just do it this way and hammer it on them with no flexibility, and also trying to give some guidelines is that we have expectations to things to be competitively bid. There may be exceptions, but they should be rare and infrequent. With that, happy to answer any questions. If I can't answer, I'm hoping Mr. Davis can.
Thank you, Senator. Members, any questions?
I have one question.
Vice Chair, please.
Very much, Mr. Chair. Thank you, Senator Daly, for presenting the bill. Would this change any current law posting requiring that certain bids or posting for bids be published in the newspaper, or would that stay the same?
Skip Daly again for the record. To my knowledge, we're not changing any of those procedures. All that would be the same, but I'm sure Mr. Davis can give further explanation if you needed it.
Thank you. Thank you, Senator Daly. Thank you, Chair.
And I may have missed it, Senator, but in Section 1, is there a specific reason we use 11 days?
Thank you again, Skip Daly, for the record. My understanding is that the 11 days is already in their statute on the process they use for people to appeal. So if you're doing the appeal, if you went to NRS 333.370, the formal appeal process, if you put in a competitive bid and you weren't there, you wanted to appeal, you have 11 days to do it. So that was the recommendation on the 11 days there.
Understood. And then I always understood sole source as you need 1,000 glasses identical to that of Senator Skip Daly, and there's only one company in Nevada that can give us the 1 million or 1,000 glasses or whatever it is, and that's why you don't put it out there for bid. But can you walk me through a hypothetical of how many of these contracts we have out there now? Well, that's not a hypothetical. Do we know those numbers? How many we have out now? And then presently, what the process is to challenge that? So maybe there's one big player in town that could give us 1 million glasses. Over the years, now there's a few other folk that came into the space. How that process works out and how they can challenge that and say, look, maybe I think I can give you a better price or whatever it may be.
Skip Daly again for the record, and I would ask Mr. Davis if he feels comfortable to come up. He'll have the answers on how many and some of that stuff. The last part about it is what do you do if you wanted to challenge the sole source? That's why we added in the notice and the objection, the first step part. Because right now, from what Mr. Davis told me, there is no process. The sole source contract goes out. Nobody may even know about it. But under this provision, what was suggested was that we should at least post it on the website and give somebody an opportunity to object if they want to do the formal appeal later. And then the purchasing division under that scenario, and not just me talking, then they'd at least know, hey, there's somebody else out there. I can look at it and say, hey, we don't have enough time. We need to go forward with this. We're going to collect that data on this person and advertise next time. Or we're going to say, hey, there's somebody else. Let's get a bid. But Mr. Davis can ask the questions on how often and what the rules are existing. My understanding, there's no requirement to provide anybody any notice when a sole source contract goes, or non-competitive without competition contract goes out.
Morning, Chair. Gideon Davis, for the record. I'm the administrator of the State Purchasing Division of the Department of Administration, and so overseeing the procurement that is done through NRS 333, the State Purchasing Act, is my primary duties as administrator. To your question about quantity, I do have numbers with regard to how many contracts were awarded via non-competitive award over the last few years versus how many solicitations were done in those same time periods. And so I have them by calendar year. And so in calendar year 2025, so since January, we have approved 12 non-competitive contracts. And in that time, we have solicited 126. So we have 126 formal solicitations that we've released during that time.
And one additional question, and I really appreciate you being here. I'm assuming that the way we determine that we only have one possible supplier or whatever it may be is because you initially put it out to bid. We only get one person, and then eventually it becomes this kind of, we're just going to repeat that contract. I'm just trying to determine.
The answer to that is, I'm sorry, Gideon Davis for the record.
Continue.
No, not exactly. We have currently in regulation, but it doesn't exist in statute, in NAC 333-150, regulations around non-competitive awards. Those regulations have been in the statute, I think, since around 2012 or so. But what they lay out is there's two situations where the administrator may approve a non-competitive contract. And then there's 5 situations where it doesn't require the administrator's approval because the state assumes that formal competition is not practical in those purposes. So for the 2 that the administrator approves, which is what's included in these numbers, one is a legitimate sole source, which is the agency has provided sufficient justification that competition cannot be possible, meaning they have demonstrated through evidence that there is literally only one vendor in the world who can do this. Usually sole source comes with things that are incredibly new emerging technology or situations where some other entity has already made that decision for us, and so we have to participate in same. And so an example of a sole source like that is there are certain places in the law, like in wildlife law related to boater education, where the law explicitly says that the Wildlife Department must work with the National Organization for Boater Education with regard to providing that testing services. And so that is a legitimate sole source because we have no ability to compete that because the legislature put the name of the vendor that we must use in the law. And explicitly said in the law that it could not be solicited or it was exempt from 333. There are other situations where the federal government mandates a particular vendor as part of a process. Again, there's a wildlife example with duck stamps where we have to use the federal vendor that produces those duck stamps, but Nevada Wildlife is buying them and they have ducks native to Nevada on them or something like that. There are also situations where I have the authority as administrator, again, under NAC 333-150, to determine that solicitation is not practicable. That sometimes falls into your example. We solicited for something, we've invested a lot in that original system, and it's not appropriate to go back out to bid right now, and so it might be appropriate to recoup return on investment to extend that contract longer than we originally intended to do so. Other situations are where the agency, for one reason or another, feels they shouldn't go out to bid. There's a process that right now, documented in NAC and through a form that they submit through our office, where they can request that. But as Senator Daley said, there is not a formal process for appeal for that. The purchasing division does complete an informal process, but it's absolutely a choice right now. We do that as a courtesy to that public because we value transparency. It is not something that's statutorily required. And so there is nothing in the statute or regulation currently, or even in the state administrative manual, that requires for public review when we award a sole source contract prior to it being submitted to the Board of Examiners for consideration. We do, however, right now, since I took over as administrator, have moved the formal process to before there was a place on the purchasing division website where solicitation waivers were posted for 5 days, and people were notified they could send us an email if they wanted to protest. When I took over as administrator, we moved to posting them in the same place that we post our competitive solicitations. So we advertise our competitive solicitations in Nevada ePro, which is our e-procurement system, and then in the newspaper as well from that system. We now post, and this bill would require us to post those non-competitive awards side by side with our competitive solicitations, so they would be advertised in the newspaper, same as the competitive ones are, and then they would that would basically elevate them equal status with those things that we solicit competitively. And then the second part that this changes is creates a formal process for protesting those. Right now, that process is informal. We post that on our website. If someone complains, me and my team review their complaint and determine whether it is legitimate or not. If it is legitimate, we rescind that solicitation waiver and we notify the agency they have to go out to bid. And if we determine that, in fact, our solicitation waiver was just, we notify them of that, and that is the end of that process. This legislation would allow someone who received a unsuccessful determination to then appeal that in the same way an unsuccessful bidder can appeal a competitive award.
And I know Senator Daley wanted to add one more point. Actually, no, please, Senator, please do, and then I'll follow up, please.
Yeah, and I just wanted to maybe give a little bit more explanation. So as I recall, on the one that the audit, in the audit subcommittee, the audit that we had, that was the genesis of this for me. as I recall on that one, so the contract went out to competitive bid and they were selected for like I said, under $100,000. And then through an extension, a variety of different reasons around that, maybe they were doing some software, and I know Mr. Davis has explained some of that stuff. You make an investment, you have a contractor, they're in the middle of writing software, you can't really switch horses and say, hey, we're gonna put out this vendor that we hired in his proprietary software out to bid. So there are reasons, and that's why I think we got some of the flexibility there. But then it changed the scope, and it kept getting extended. And then, as they said, there was questionable use of the sole source waivers. I'm not sure if Mr. Davis was there then. I don't think that he was. And that extension went out, several years and grew to, like I said, $16 million without ever going back out to competitive bids. So a lot of that, those are the things, and those are the things that I tried to talk about with Mr. Davis as we tried to find the flexibility, but still, and I think through the regulations, develop a process and a policy to make sure those types of things don't happen as a way to evade. Because I think that was the case on the one example that I gave that got me onto this was there was a plan by somebody who was either not wanting to do this or didn't have the staff to do it, or they weren't exactly in conformance. I want to say that they lied, but they weren't exactly in conformance with the request that got to go in to get a waiver.
Great, thank you. And so in that hypothetical that you put out a competitive bid, you get one individual, one company that bids on that and they get it. Does that happen often that you have a scenario where you're putting it out there, but you're only getting one person or one company?
Gideon Davis for the record. Yes, that does occur. I wouldn't necessarily say often, but it does occur. There are examples where we solicit for something and only receive a single response. There are situations where that single response still doesn't meet our requirements, and we then have to cancel the solicitation, potentially rewrite our requirements and resolicit. And then there are situations where that single vendor is deemed to be qualified and we proceed with a contract because we attempted competition and we can only control our own actions.
Fair enough. And thank you again. Senator Rogich, please.
Thank you, Chair. Good afternoon. I just have a question. Listening to you go through the process, how long does it take to go through the solicitation, and then if somebody challenges, and then reposting of solicitation, and then finally selecting and entering a contract with a vendor?
Gideon Davis for the record. For our solicited contracts, the normal timeline is approximately 4 to 6 months from when we start the solicitation process until a contract is awarded and executed. If a contract is appealed, NRS 333-370 lays out the timeline for an appeal. As Senator Daley said, the initial timeline after we execute or release the notice of award, the unsuccessful vendors have an 11-day period with which they have an opportunity to appeal that award. That appeal must be filed with the Purchasing Division and the Hearings Division and must state an alleged violation of NRS 333, the State Purchasing Act. If the Hearings Division receives an appeal, they then have to schedule a contested hearing within 20 days. So that's 11 days plus 20 days. We're now at 31. After that contested hearing occurs, they then have to release a finding within 60 days. So that's not additive to the 20, it's 60 days total. And so that is 71 days from award of a contract until we receive a decision from the hearings decision in the event we are appealed on a solicitation. If we are appealed, that acts as a stay as the contract, and the state cannot proceed with execution of that contract until the appeal is completed.
Please follow up.
Thank you, Chair. That's a long time. Gosh, so you're talking about 9 months. What does the state do while waiting for all this process to play out?
Sometimes, Gideon Davis for the record, sometimes the state is forced to award non-competitive contracts during that time that we sometimes call bridge contracts, a contract for a period while we are soliciting. Sometimes we are required to extend the contract beyond the originally intended term, as Section 2 of the bill addresses, where if an RFP is unsuccessful or has to be canceled and we have to go out to bid, then sometimes we have to extend with the previous vendor or find a vendor in some sort of informal process because it's potentially an emergency situation at that point in order to continue services while they're replaced. However, if the services that we're soliciting for are not mission critical, there may be situations where the agency has a lapse in project, or a project doesn't get to start until the solicitation process is complete.
Can I make a couple of comments on that particular question? The 4 to 6 months sounds like a long time, but with the public money and various things, so they have to develop what the proposal is, and I believe that's in part of the time. Then they have requirements in there that you have to advertise it for a certain period of time. Oftentimes in that, I see it on the construction side more than this side, people will say, what do you mean by this particular question? So there's a comment period. They can come back and forth and say, hey, what does this mean? And then if they make an adjustment, they say, hey, that's a good question. We're not as clear. This is the new intent. So then they would send that out to all the rest of the bidders, and it extends a little bit of time. So there are things that are built in to make sure we're getting the competitive price. We're not trying to drag it out for 9 months. And then the appeal process is the appeal process. That's kind of out of everyone's control. I don't think it happens as often as you might think, because he left out the part that if you go to the official appeal, you have to put up a bond. It's not just a frivolous complaint or whatever. You gotta put up the bond that you may have to pay damage to the state for delaying. So it's you have to be serious about that objection and that there was a violation to do that. The state tries not to get caught up in that. They don't like to lose those, so they try to be as cautious as they can and make sure they got it right. So there are some built-in precautions on how the process goes on purpose. I know it sounds like a lot of time. And then, Mr. Davis alluded to, sometimes there are using agencies or the people that are saying, hey, we want to put in this, that are working through the division that maybe waited too long to start that process. No, they can't get it. So they say, well, you have to give me an extension, or, prisoners in the prison are not going to get fed if you don't give me the extension. And that's where we're trying to tighten up some of those things. So if he gets that extension, it's gone past the original intended period, and then any period that was included in the solicitation. If it goes past that extension, can't be more than 4 years. It could be less. And then they're going to get direction to say, you got to go to bid. And if you don't, that's when you're going to get on the bad list and come in front of the Legislative Commission and say, why are you not doing the competitive bidding that the state requires and needs to have happen? And some of that, goes back to some other processes and that. But unfortunately, there are situations where people may do this with a plan in mind.
Vice Chair, please.
Thank you, Chair, and thank you, Administrator, for helping with my question about the publishing and the posting in newspapers. In addition to that web portal or website that you mentioned, I think it was I didn't quite catch the name, but one question about that. Do you kind of roughly know how many people would get notice who subscribe to that website, and what's involved for people or businesses to be subscribed to that website so they would get notice of this non-competitive bid?
Gideon Davis for the record. Yes, that website is Nevada ePro, NEVADAEPRO.com. ePro stands for electronic procurement. And so NevadaePro.com is the state's electronic procurement system for supplies, materials, equipment, and services. NDOT has a different system for their construction projects, and the Public Works Office has a different system for their construction projects. But if it's supplies, materials, equipment, or services, state agencies and the purchasing division solicit through Nevada ePro. To your question about registration, any member of the public or a vendor can register in Nevada ePro. You are required to provide a tax ID number. So if you're a vendor, that's your company tax ID number. If you're a member of the public, you would have to provide your social security number because you are registering as a vendor in the system, even if you're an individual. When someone registers in the system, there's no cost to that. It takes maybe 10 minutes. It's an online system. It's self-registration. When they register in the system, as part of the registration process, they select commodity and service codes. So it's a 5-digit code that from the Institute of Public Procurement that classifies all supplies, materials, equipment, and services that governments buy. And vendors can choose as many of those codes as they want. And then when we release a solicitation, we select from the list of vendors everyone who signs up for the commodity code for that particular solicitation. And so depending on the type of solicitation, that can be between, you know, a minimum of 3 vendors, but on most solicitations, it's over 100. On some of them, like the recent solicitation that's currently in evaluation for temporary employment services, I think that solicitation went out to about 500 vendors.
And Mr. Chair, along those lines, purchasing division, I don't think advocated for themselves as well. Or to get to the part of the question I think you were looking at about who's on this and how they do that. I believe, and we've passed legislation, various things that directs almost all of the purchasing around the state to have a program to go out and recruit and notify all types of different businesses, small businesses, disadvantaged business, various things. So that outreach already happens. All of that is still in place and happens because the state does want to try to attract and make sure that they have people that know about it and have people bidding on it competitively. That's to the advantage of the state. The more people, the more competition we have, and the more access by as many people as we have. And I believe those are ongoing programs. That they have. So he didn't mention that, but I think that was part of your question.
Thank you, Senator. Thank you, Administrator. Thank you.
Members, any additional questions? Seeing none, thank you again for the presentation. I'd like to invite both of you to sit back in the gallery, and I'd like to invite those wishing to testify in support of Senate Bill 313 to please come forward. Carson City or Las Vegas? Seeing none, do we have anybody wishing to join us over the phone in support of Senate Bill 313? BPS, please.
If you would like to testify in support of Senate Bill 313, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to testify in support at this time.
Thank you. At this time, I'd like to invite anybody wishing to testify in opposition to Senate Bill 313. Seeing none in Carson City or Las Vegas, BPS, anybody wishing to testify in opposition to Senate Bill 313?
If you would like to testify in opposition of SB 313, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to testify in opposition at this time.
Thank you. And at this time, I'd like to invite anybody wishing to testify in the neutral position to Senate Bill 313 to please come forward. Seeing none, BPS, anybody wishing to join us in the neutral position for Senate Bill 313?
If you would like to testify neutral on SB 313, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to testify neutral at this time.
Thank you. Senator Daly, any closing remarks you may have?
Mr. Chair, thank you again, Skip Daly, for the record. I don't pretend to know everything about purchasing. I know little. I've learned a great deal. I believe Mr. Davis was giving me good information and facts, and I think that this bill will at least give us the opportunity to tighten up some of the issues that were identified in that audit. And I think the regulation part is the key to get some of those policies written down. So anyway, with that, I do think the bill will achieve its intended goal. Is it the silver bullet and going to fix everything forever? No, but I think it'll be a step forward. And thank you.
Thank you. And with that, we'll go ahead and close out the hearing on Senate Bill 313. I did notice that some folk joined us just recently. Just wanted to make some clarifying points. We were at the call of the chair because we have the State of the Judiciary scheduled at 4:30 today. We were concerned that if we met at 3:30 as we are regularly scheduled, that we would not have finished in time. We would have to cut a hearing in half, go to the State of Judiciary, and then make our way back to the committee room and more than anything else, mess with our incredible team. And in the interest of helping them, we met a little bit earlier. Members, we're going to be doing the same thing for for Friday. I know we are typically scheduled at 3:30, and in the past weeks, we've been canceling Fridays. But moving forward, we're going to have to, in the interest of meeting our deadlines, meet on Fridays. But we are going to be at the call of the chair. It is my intention to meet at the conclusion of Senate Judiciary, Senate Education, so that we can get the ball rolling and move immediately into our committee hearings. I suspect that we will be starting probably closer to around 1 p.m. on Friday, but it will be at the call of the chair because we're trying to coordinate with other committees around us. The only other item that we have on the agenda for today is public comment. For those of you that intended to testify in a particular bill, although we traditionally do not do this, I would like to give you an opportunity to do so now. If you were going to testify in a particular bill, should you want to put that during public comment, that'd be completely okay. Anybody wishing to join us for public comment, Carson City or Las Vegas? Good afternoon, welcome.
Good afternoon, Chair Flores, members of the committee. I appreciate your flexibility. My name is Charlie Donahue, and I'm the administrator for Division of State Lands. I just had a comment. I would have testified in neutral, but I'm respectfully asking that your Legislative Council's Digest on page, sorry, for SB 340. Legislative Council Digest on page 4, line 159, where it references case law and the authority of Killebrew versus State Donahue. I'm respectfully asking that Donahue is spelled correctly, D-O-N-O-H-U-E. My high school yearbook had my name misspelled, and my mother was very, very upset. So anytime I do see my name misspelled, I like to have it corrected, considering its reference to case law. And those are my comments. Thank you, Mr. Chair.
Thank you. I'm glad we caught you in time. That's probably the best public comment we've had in a long time. We appreciate you joining us today. Do we have anybody over the phone wishing to join us for public comment? BPS, please.
If you would like to provide public comment, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 702, you are unmuted. Please continue.
Good afternoon. Can everyone hear me okay?
Yes, we can. Please proceed.
Excellent. Good afternoon, Chair and members of the committee. For the record, my name is Noah Villa, first name N-O-A-H, last name V-I-L-L-A. I'm calling in regards of Senate Bill 279. I strongly urge the committee to support Senate Bill 279. I was affected by DPS not providing adequate notice of an internal peace officer investigation, and I'm currently pursuing a grievance. And those are my comments. Thank you very much.
And thank you for the work that you do to keep our streets safe. We'll make sure that we have that included in our notes. Thank you. Anybody else wishing to join us in public comment, over the phone?
Chair, you have no more callers at this time.
Thank you. All right, members. So one additional point that I wanted to highlight for everybody for next week, we also will likely be meeting in the next 2 weeks, possibly on a Tuesday or a Thursday, that we're looking to try to add a few more bills to be heard. We will notify you as soon as we have that date locked in. We're just trying to coordinate around other committees that may meet on Tuesdays and Thursdays. And that is in an effort to try to minimize how lengthy our Fridays have to be, to give everybody ample time to get back to your families and try to get as much of the weekend as possible. But the only way we can achieve that objective is by stacking Mondays and Wednesdays, and then adding some Tuesdays and Thursdays so that we can keep Fridays to 3 bills at maximum, but hopefully 2. So that hopefully everybody has an understanding of what we're trying to achieve. I appreciate everybody's indulgence and working with our flexibility here. This meeting's adjourned.